What is the assumption of risk? In the realm of personal injury law, comprehending the concept of assumption of risk is crucial. While many individuals seek compensation for injuries resulting from someone else's negligence, there are instances where the injury victim is deemed to have knowingly accepted the risks associated with a specific activity. This acceptance might hinder their ability to pursue legal recourse for their injuries. Exploring express assumption of risk. Express assumption of risk is a straightforward acknowledgment by an individual that they willingly accept the potential dangers of a hazardous activity. Often, this acknowledgment is formalized through the signing of a liability waiver. Such waivers are prevalent in various situations, including amusement parks, sporting events, vehicle rentals, adventure activities like bungee jumping and skydiving, cruises, and even routine medical care. When a person expressly assumed risk for activities, this limits their options to recover compensation if they sustain injury during an activity. There are exceptions, particularly if the injury occurs as a result of the gross negligence of another party involved. Waivers in different scenarios. Sporting events. Attendees at sporting events commonly sign waivers, recognizing the inherent risks associated with the activity. Vehicle rentals. Renting a vehicle involves signing a waiver, acknowledging potential risks during the rental period. Adventure activities. Activities like bungee jumping and skydiving require participants to sign waivers explicitly accepting the associated risks. Recreational pursuits. Renting a boat or jet ski, enjoying a cruise, or even attending amusement parks often involves signing liability waivers. When individuals expressly assume the risk of an activity, their options for seeking compensation diminish, barring cases of gross negligence by the involved party. Unpacking implied assumption of risk. Implied assumption of risk occurs when an individual knowingly engages in a potentially perilous activity without a formal agreement, either written or verbal. In such cases, it is understood that the person is aware of the risks but proceeds nonetheless. While no formal agreement may be in place, individuals engaging in such activities are presumed to have a reasonable understanding of the inherent risks involved. Exploring liability despite assumed risk. The question arises, can individuals still hold others liable for injuries sustained even when assuming the risk? Despite the challenges posed by signed waivers and explicit consent, pursuing a personal injury lawsuit is not entirely precluded. The enforceability of a waiver depends on several factors. Factors influencing waiver enforceability. Clarity of language. The waiver's language must be unambiguous and clear for it to be considered legally binding. Injury circumstances. Examination of whether the injury aligns with the risks the waiver aimed to protect against is crucial. Compliance with laws. Waivers should not violate any laws or public policy to be deemed enforceable. As a rule, individuals can still hold accountable those who, through negligence, recklessness, or intent, cause harm, regardless of the assumed level of risk by the injury victim. While assumption of risk poses a challenge, legal avenues remain open for those seeking justice after sustaining injuries. Is liability still possible? In the event of sustaining an injury, individuals retain the right to pursue a personal injury lawsuit against other parties, notwithstanding any assumption of risk. While the presence of a signed waiver and explicit consent may complicate the process of seeking compensation, the ultimate decision lies within the purview of a jury. A person has the option to initiate a civil personal injury lawsuit, assisted by an injury lawyer, against another party, alleging that the negligent actions of said party were responsible for the injury. The enforceability of a waiver typically hinges on three key factors. Was the language in the waiver clear and unambiguous? Did the injury result from an act that the waiver aimed to protect against? Did the waiver infringe upon any laws or public policies? As previously highlighted, individuals can still be held accountable for their actions if they negligently, recklessly, or intentionally cause harm to another party, irrespective of the assumed level of risk by the injury victim. Frequently asked questions, FAQs. Q1. Can I still sue for personal injury if I signed a waiver? A1. Yes, signing a waiver does not entirely preclude you from pursuing a personal injury lawsuit. The enforceability of the waiver depends on factors such as clarity of language, injury circumstances, and compliance with laws. Q2. What if the injury results from gross negligence? A2. In cases of gross negligence by another party, you may still have options to seek compensation, even if you've assumed the risk through a waiver. Q3. Are waivers always legally binding? A3. Waivers must have clear and unambiguous language, align with the circumstances of the injury, and comply with applicable laws to be considered legally binding. Q4. Can I hold someone accountable for intentional harm, despite assuming the risk? A4. Yes, intentional harm by another party, regardless of assumed risk, can still be grounds for holding them legally accountable. Q5. How can I determine if a waiver is enforceable? A5. Evaluate the waiver's language for clarity, assess whether the injury aligns with the risks outlined in the waiver, and ensure the waiver complies with relevant laws to determine its enforceability.